A Supreme Court case is happening right now that could flip your concealed carry rights upside down overnight. And if you carry in any state at all, this ruling will directly affect where you are legally allowed to bring your gun. Think about this. Every store you walk into, every restaurant you eat at, every gas station you stop at, this case decides whether you need permission to carry in all of those places, or whether a no-gun sign is enough. The answer the Supreme Court gives could rewrite the rules in all 50 states. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal could save you from up to 1 year in prison. Right now, a huge portion of people watching this aren't subscribed, and that means they miss updates exactly like this one. Hit that subscribe button right now. It's free, it takes 2 seconds, and it could be the most important 2 seconds you spend a day. All right, let's get into it. The case is called Wolford versus Lopez, and this is one of the biggest Second Amendment cases to reach the Supreme Court in years. Oral arguments already happened on January 20th, 2026. A final decision is expected by summer 2026. Here is everything you need to know. Broken down in plain English, no law degree required. Let's start from the very beginning. Back in 2022, the Supreme Court decided a landmark gun rights case called Bruen. You might have heard of it. In that case, the court said that states cannot restrict your gun rights unless those restrictions match America's historical tradition of gun regulation. In other words, if the government wants to limit your Second Amendment rights, they have to point to a similar law from the 1700s or 1800s. If they can't find one, the restriction is probably unconstitutional. That was a massive, massive win for gun owners everywhere. But here's what happened next. Hawaii, one of the most restrictive gun law states in the country, came back fighting. In 2023, Hawaii passed a new law called Act 52, and this law included something that gun owners had never dealt with before. Legal experts actually gave it a nickname. They call it the vampire rule. You know how in vampire movies, a vampire cannot enter your home unless you personally invite them in? Hawaii took that exact idea and applied it to guns. Under the vampire rule, if you have a valid concealed carry permit, you cannot bring your firearm onto any private property that is open to the public unless the owner gives you specific permission first. That permission can be verbal, written, or posted on a sign, but you need one of those things before you can legally carry. Now think about what that really means for your daily life. You wake up in the morning, you put on your carry gun, you drive to the gas station. The gas station is private property open to the public. Under Hawaii's law, you cannot carry there unless the owner says it is okay. Then you stop at the grocery store, private property, permission required. You grab lunch at a restaurant, private property, permission required. You park in a shopping mall parking lot, private property, permission required. Basically, everywhere you go during a normal day, you need express permission before you carry, and here is the part that should really get your attention. If you get this wrong, if you walk into any of those places with your carry gun and you do not have that permission, it is a misdemeanor. That means up to 1 year in prison. Not a fine, not a warning. Prison time. For walking into a store with a gun, you are fully licensed to carry. 3 residents from Maui with valid concealed carry permits decided they were not going to accept this. They teamed up with the Hawaii Firearms Coalition and took the state to federal court. They argued that the law was unconstitutional. A federal judge in Hawaii agreed with them and actually blocked the law from being enforced. But then the state of Hawaii appealed that decision. The case went to the Ninth Circuit Court of Appeals, which is the federal court covering Hawaii, California, Oregon, Washington, and a handful of other western states. And the Ninth Circuit ruled that Hawaii's law was constitutional. The vampire rule could stay. Here is one detail most people completely miss. California had passed a very similar law around the same time. But California's version was even stricter. California said you could only give permission through posted signage. Hawaii said you could give permission verbally, in writing, or by signage. The Ninth Circuit actually struck down California's version for being too restrictive, while letting Hawaii's version survive. That tells you how close these legal lines are being drawn. If you are finding this helpful, imagine what I have lined up in my next video. I'm covering the exact 5 words you should never say when a law enforcement officer asks if you are carrying. That video could protect you in ways you have not thought about yet. Subscribe right now so you catch it the moment it goes live. So the challengers from Maui were not done. They went straight to the United States Supreme Court. In October 2025, the Supreme Court agreed to hear the case. That by itself is significant. The court only takes a small percentage of cases that come to them. The fact they said yes means this issue matters at the highest level of the American legal system. Oral arguments were held on January 20th, 2026. That is when both sides stood before all 9 justices and made their case. Here is what the gun owners argued. They said the Second Amendment is clear. You have the right to keep and bear arms. That right does not disappear the moment you step onto private property that is open to the public. They pointed out that almost every public-facing space in America sits on private property. Stores, restaurants, gas stations, shopping centers, parking lots, all of it private. So if you need permission at every single one of those places, you effectively cannot carry anywhere outside your own home. That, they say, is a direct violation of the constitutional right that Bruen reaffirmed. They even compared it to the Supreme Court's famous Brown versus Board of Education ruling on school desegregation. They said, after that decision, the Supreme Court did not allow states to resist and dodge the ruling. States had to comply. Gun rights should be treated exactly the same way. Then here is what Hawaii argued. Hawaii said, look, this is not really a gun rights issue at all. This is a property rights issue. Property owners have always had the right to control who enters their property and how. You have never had a constitutional right to walk onto someone else's private property without their consent. So all Hawaii is doing is clarifying that the public's general permission to enter a store does not automatically include an invitation to bring a firearm. That is property law, not gun law. Hawaii also tried to find historical backup for their position. They pointed to a 1771 New Jersey law and an 1865 Louisiana law that restricted guns on private property without owner consent. They argued those laws prove a historical tradition exists for this kind of regulation. But this is where it gets really interesting. And this is the part that shocked me when I read the court transcripts. The gun owners fired back hard on that Louisiana law. They pointed out it was passed in 1865, right after the Civil War, as part of Louisiana's Black Codes. These were laws specifically designed to strip rights away from formerly enslaved Black Americans after emancipation. Several Supreme Court justices, including Justice Alito, raised serious questions about whether laws with that kind of discriminatory history and motivation should count as legitimate constitutional precedent. That is an enormous problem for Hawaii's historical argument. Now, quick legal note right here. Everything in this video is educational information only. It is not legal advice. I am not your attorney. For your specific situation, in your specific state, please consult a licensed attorney. Hey, right now, 73% of people watching this video have not subscribed yet. That means almost 3 out of 4 of you are going to miss the follow-up video when the Supreme Court ruling actually drops. Do not be in that group. Join the 50,000 gun owners who trust this channel for honest, no-nonsense legal breakdowns. Hit subscribe right now, 2 seconds. That is all it takes. Now here's the part nobody is really talking about, and this is the biggest reason this case matters far beyond Hawaii. Let's say the Supreme Court rules in favor of the gun owners, which many legal observers actually predict, given the court's current conservative majority. What actually happens? First, and most obviously, Hawaii's vampire rule gets struck down. Gone. But that is just the start. There are 5 states that currently have laws similar to Hawaii's. Hawaii, California, Maryland, New York, and New Jersey. A ruling against Hawaii would almost certainly pull those other state laws down too. 5 states, millions of gun owners, changed overnight. But the bigger story is what happens to the default rule for private property carry across all 50 states. Here is what the default rule means in plain terms. In most states right now, the default is this. If a business is open to the public and they have not posted a no-gun sign or told you to leave, a licensed carry holder can generally bring a firearm inside. The default is that you are allowed. The burden is on the property owner to say no. In Hawaii and those other 4 states, that default was completely reversed. The new default was, you're not allowed anywhere unless the owner specifically tells you that you are. The burden was shifted onto the gun owner to get permission. That single flip is what this entire case is about. If the Supreme Court rules that flipping that default is unconstitutional, they are sending a message to every state in the country. You cannot force a licensed carry holder to ask permission to exercise a constitutionally protected right in publicly accessible spaces. If you want to keep guns out, you post a sign, you make it clear, but you do not get to assume they are not welcome. And this is where gun signs become enormously important. You know those no firearm signs you see in store windows all across the country? This case could determine exactly what legal weight those signs carry from state to state. Right now, in some states, ignoring that sign is a civil matter. You might get asked to leave. In other states, ignoring that sign is a criminal offense. A Supreme Court ruling here could bring more national clarity to that entire question. Here is a hypothetical example to make this concrete. Imagine you are a gun owner in California with a valid carry permit. Under current law, you walk into a coffee shop. You need permission before you carry inside. After a ruling in favor of the gun owners, that could change. The burden would shift to the coffee shop. If they want to keep guns out, they post a sign. If there is no sign, your carry is presumed to be welcome. The burden of exclusion belongs to the property owner, not the burden of seeking permission on the gun owner. And this is the mistake most people make when they hear about this case. They think it is just a Hawaii issue, something happening far away that does not affect them. That thinking is wrong. The Supreme Court's ruling here will be the binding law of the land. Every state, every court, every local prosecutor. They all have to follow it. Whether you are in Texas or Oregon, Florida, or Minnesota, the principle this ruling establishes will define what your carry rights mean on private property. This information could literally expire the moment the ruling drops, which could come as early as June or July 2026. And the second that decision is public, I'm releasing a full state-by-state breakdown of exactly what it means for you specifically. Subscribe right now so that video lands directly in your feed the day it goes live. That breakdown could tell you exactly what you need to do, or stop doing, before your rights change or get confirmed. So let us bring everything together. Wolford v. Lopez is a pending Supreme Court case. It asks whether Hawaii, and states like California, New York, New Jersey, and Maryland, can legally require licensed carry holders to get explicit permission before bringing their firearm onto private property that is open to the public. Oral arguments happened on January 20th, 2026. A final decision is expected this summer. If the gun owners win, and the majority of legal observers believe they have a strong case, the vampire rule dies. The permission first default in 5 states gets overturned. And the national framework for private property carry shifts back to putting the burden on property owners to say no rather than on gun owners to ask yes. Do not wait for this ruling to hit the news before you figure out where you stand. Know the laws in your state right now. And stay close to this channel for the moment the decision drops. I put hours into every single video, reading court briefs, digging through legal transcripts, separating the important stuff from the noise, so that you get a clean, clear, honest update instead of 3 hours of legal jargon. If that work means anything to you, hit subscribe. It is completely free. It supports everything this channel does, and it makes sure you never get blindsided by a ruling that could change your rights overnight. Final reminder, this channel provides educational information only. Nothing in this video is legal advice. Nothing here creates any attorney-client relationship. Laws vary by state, and your specific circumstances matter. Always consult a qualified, licensed attorney before making any decisions based on what you hear here. Stay safe, stay informed, stay legal, and I will see you in the next one.